Got to wait a few seconds before it goes. If cameras go on, I can do it. Okay, we're on. Order. Thank you very much to our witnesses for coming today. We are having a special session today as the Home Affairs Select Committee looking at the Modern Slavery Act 10 years on. It seems unbelievable to me that it was 10 whole years ago that we got that royal assent and the Modern Slavery Bill became the Modern Slavery Act. We're hearing today from professionals and those people who are engaged in working in the field of modern slavery. We are acutely aware as a committee that this is an area which victims have to be front and centre of all the work that is done. And on other occasions we would hear from victims, but because of this being a one-off session, we're not hearing from victims on this occasion. That doesn't mean that we won't hear from victims in the future, and it doesn't mean that we, as I say, do not put them front and centre of the work we do, because they are absolutely vital, and we need to make sure we find those victims and make sure they get the support they need. So I just want to be absolutely clear on that before we start. I wonder if perhaps the witnesses could introduce themselves and then we'll start our questioning. So perhaps start with you, Caroline.
Thank you. Good morning. My name is Caroline Haughey. I'm a King's Counsel barrister. I am in independent practice, but I specialise in the prosecution of modern slavery, human trafficking and exploitation cases. I was privileged enough to work with Dame Karen in the drafting of the Modern Slavery Act. I prosecuted the first modern slavery case in Britain and have been involved in this sector ever since.
Hi, I'm Emma Hawley. I'm an Assistant Director for Barnardo's, working in the Independent Child Trafficking Guardianship Service. I've been lucky enough to work on this project since it began, so that's a really positive thing for me. And I'm one of the managers who covers our service supporting children and young people who have been trafficked and exploited.
Good morning, I'm Major Cathy Betteridge and I'm the Director for our Anti-Trafficking and Modern Slavery work for the Salvation Army across the United Kingdom and Ireland, and we've been held to the prime contract for the MSVCC and the previous contract since 2011, so we've been able to support victims of adult victims of modern slavery since then.
Thank you. Thank you very much. So I'm going to start with a question in light of the recent House of Lords report on modern slavery, which said that the world has changed and best practice has moved on. What do you see as the main causes of the changes we've seen? Perhaps I can start with Caroline.
Thank you. I think with the benefit of reflection and having had the privilege of being involved in the creation and investigation of that report, criminality has changed. The world has pivoted to a degree on its access as a result of COVID, and we are a much more digitally driven society. And we, as investigators and I, as a prosecutor, need to adapt to meeting that. It is often harder, ironically, for victims to become identified. But on the flip side, a lack of digital footprint is a means of identification of victims. I think the rest of the world has caught up with the Modern Slavery Act, but I think we have lagged behind in our application, and I'm talking about this on a global scale. The definitions that we're working with outside of the UK, I'm talking on a global scale, I don't think necessarily meet the way criminality and exploitation takes place today.
Thank you. Emma?
I think I would agree the definitions are probably need to be updated and changed in line with what we're seeing in terms of what's happening for children and young people. A lot of the changes in the experiences that we see for children and young people, there's a lot of similarities from when I started working in this field, but equally the exploitation that they experience sort of moves and shifts around them and it adapts, like you say, in terms of the digital world events. I think, unfortunately, we're living in a world where people will find new and creative ways to take advantage of others and make money from them and benefit from them. And that's what we see happening for the children and young people that we work with.
Cathy?
I think that the Modern Slavery Act was a turning point in the UK, and the response to it has been varied across the years. There's been a greater awareness, so there's definitely a shift in understanding, but probably not to the extent that we all would like and would all want to see. Victims and survivors are perpetrated in ways that go beyond any of our thoughts and imaginations, really. And we've noted that in the early years, when very few people were referred into our service, as time has gone on, from 2015 to 2024, the numbers have increased, which would indicate a number of reasons, of course, but raising awareness and the awareness of modern slavery has certainly increased.
Thank you. Just picking up on the definitions point, so what would you like to see change? Clearly, Palermo Protocol and Council of Europe and all the various agencies over the years have come up with their definition of human trafficking, but what do you think needs to be changed now?
I think, bearing in mind recent experience that I've had, what I'd like to see is a less rigid definition of exploitation, because when the Modern Slavery Act was crafted, for example, we didn't foresee county lines as being a form of criminality. But the wonderful thing about legislation is it's supposed to be living. The law is a living instrument. And the Modern Slavery Act has moulded in the right way to be able to prosecute that kind of offending. In a recent case that I did, where we really struggled, was demonstrating the terms of forced and compulsory labour and explaining that to a jury of malice and intended malice. And those are concepts that are quite constrained and limiting. And they are bound, in fact, by UN directives. We're working with, I think, what can be quite limiting, when the whole purpose behind when we crafted the Modern Slavery Act was that it was exemplary, not binary. By contrast, say, for example, to the Bribery and Corruption Act. What is exploitation? Well, it's a multitude of things, and you'll know it when you see it. And I think if we pursue that in our definitions, if we keep that as our kind of pivot to work to, then actually the Modern Slavery Act and all the subsidiary legislation upon which it's predicated will ensure that the Act continues to be living and continues to really deal with the exploitation that is happening.
And certainly the new crime and policing bill has got a new offence of child exploitation.
Yes.
Which does strike me as slightly at odds with the fact we already have an offence of exploitation.
Absolutely.
And murder is murder. You don't have child murder and adult murder. So do we need to have a child exploitation offence? Do we just need to change actually some of the wording around the offence of exploitation?
You've hit the nail on the head, if I may say. That is actually my personal view. We have had cases, the first child labour exploitation case in the UK, Operation Field, dealt with young Vietnamese females who we believed to be 15. Now, actually, proving their age didn't become an issue in the case because, A, we didn't call them. We were able to do it victimlessly. But more importantly, that would have become satellite litigation. They were exploited. Full stop. It doesn't matter whether you're an adult or a child. Where the fact that you're a child and are exploited or should be relevant to amplify the sentence, not the original offending. And that's where I really struggle with over-legislating a problem when we need to look at what is the core problem. Who is being exploited and how are they being exploited? And I don't mean who it's a child, I mean who the individual, and adapting our approach in that victim-centric way.
Thank you. We may need to have a conversation about possible amendments, but let me bring in Robbie Moore.
Thank you. Thanks, Chair. I just wanted to get an understanding of how you feel cross-government working is happening on the basis of the Act coming in. And maybe Emma, if I start with you, just how effective is cross-government working since the Act came into place, in your opinion?
I mean, I think we're looking at a number of different areas that have to work together, and bringing all that together is really, really hard. I suppose our experience is much more at the local level, kind of looking at different agencies that are needing to work together to collaborate, to share information, and that's definitely improved over the time that we've been working in the services. We see some amazing partnership work where colleagues are willing to come together, be open about what they know and what they don't know, and share their perspectives and work together to support children. I think it's back to that piece about ongoing awareness raising, people understanding definitions in some way, because it's useful to have a boundary and a starting point, but a broader perspective of what exploitation is and can be, recognising indicators and all of those things move it forward. We've seen some real positives through the evolution of the devolved NRM panels, the National Referral Mechanism panels. We're involved in 10 of those, sort of representing children, representing our service in those settings. And there is some fantastic work done at local level, moving decision-making around children's circumstances where we're seeing exploitation at quite a quick pace, which can be a really positive thing in terms of the people that work and know those children, having access to the information about them, being able to share that, talk about what's happening, having a local picture as well, and make decisions that are really informed about children and young people. So there's some real positives in that way.
Okay. And Kathy, is there anything additional that you'd like to add to that?
We need to see stronger working together across departments within government. We're experiencing difficulties in relation to our adult survivors as they move on from our specialist service, because housing is a real issue. So we're finding that there's lack of housing within local authorities, that the victims of modern slavery aren't seen as a priority need. Local connection can make it difficult, especially for British victims as they move out, because they've moved from their area where they've lived to another area and therefore can't find housing. Mental health support is also an ongoing concern and issue, and legal aid. So there isn't a joined up approach, and our conversations with our Home Office colleagues, identifies that and reiterates that on so many occasions. We were very pleased to see the safeguarding modern slavery being put back into the safeguarding portfolio with Minister Jess Phillips. So we were really pleased about that, and we're pleased that there's better communication, I'd say now, with the current government, and where the re-establishment of roundtables and other forums that is happening, which is good. But the wider support for our victims needs to be more joined up, and a strategy in place to work across departments.
And if I was to, because the common theme is always wanting, obviously quite rightly, more collaboration across government departments because of some departments being a bit more siloed in their thinking. How, just to push both of you, how do you feel that we achieve that? Is there something that needs to go above and beyond to ensure that proper, true collaboration to deal with dealing with modern slavery needs to be enacted through at the top from Downing Street, so to speak? Is there something additional that you'd like to see?
I mean, we would be really keen to see, a SPOC in every local authority area, so that there was a real awareness of the issues that some don't maybe think is happening in their area. But if there was a single point of contact within a local authority that had a modern slavery portfolio, then that would help us to really target and access the support that our survivors need.
And Emma, anything in addition to that?
No, I think that would be an excellent idea. I think Chris wants to come in.
Yeah, I just wanted to ask on the cross-government work. We've obviously got the establishment of the new Fair Work Agency coming down the track, and I just wondered if you had any thoughts on its role in facilitating cross-government working on this. You may not, it's not come into existence yet, but...
I don't have thoughts on that, but can I just come back on something that my colleagues have said? We really see a disjoint in prosecution between agencies. I'll give you an example. In Operation Field, the case I just referred to with the Vietnamese girls, who we do now know are 15, because if I told you that one of them subsequently went back to her perpetrator, had 2 children with him, and he sought to gain asylum in the UK on the basis of them being in a loving relationship. And the date of age he gave for her was 15 at the time of offending. Yeah, we use that as evidence. But during the process of that trial in Stafford, the Home Office tried to deport our victim back to Vietnam. So there is a total disconnect in a policing perspective. We've had the same problem. I've just finished prosecuting a case with a Ugandan female who was brought into the country by a Ugandan High Court judge. A human rights expert, I might add. But the Home Office, A, provided us with the wrong evidence on which to prosecute the case, but more importantly, her asylum application was rejected in the first place. And that was potentially a strand of evidence that was going to be deployed by the defence in undermining the victim. Now, they have to be 2 separate processes, but the whole process was taking place in the Home Office without any thought or consideration to all the criminal material that she'd provided the courts with. And if we don't break down these barriers of communication and realise we're all on the same page, the whole purpose of the National Referral Mechanism is to identify people who are victims of trafficking. Not everyone who goes to the NRM is telling the truth. I'm the first person to recognise that. But when someone is credible, there needs to be a proper joined-up thinking, recognising that the police are doing their safeguarding best. They're seeking to disrupt organised crime groups and punish perpetrators. And if we don't build up a means of fair and easy communication, then both sides are losing out. And that defeats the entire purpose of what we're here for. So from my perspective, it's different because my interaction with the victim is very limited. I get to meet them at court. I don't get to have a relationship with them. But I am the voice that they have in order to be able to put forward their account in court, which is we, three of us, recognise often the first opportunity they have. And if we don't share information, then we're not using our best platform to enable the survivor to give their account and to prevent people doing this again.
Tony Reid wants to come in.
In light of what you've just said, would you then say that Section 45 of the Act is not fit for purpose and isn't working?
So that's a really complex question. Typical lawyer. I think Section 45 can and should work. I have seen an evolution of the Court of Appeal interpretation of how we should apply Section 45, both as prosecution counsel and as defence counsel. And when it is properly applied, and we objectively, removing subconscious bias, look at an account and decide whether it is in the public interest to prosecute someone, then I think Section 45 can be effectively deployed. And I have seen it being effectively deployed. We prosecuted Operation Fort. We had 350 victims. Some of them were groomed into roles of control. We looked at their roles to decide whether or not it was in the public interest to prosecute them as the perpetrators, or were they just victims who, for their own means of survival, had been given more power than others. So we applied it using our common sense. Now, perhaps that's because we're more experienced in this. I think that Section 45 applied properly works. The problem is it's not applied properly. And that, I think, is the problem, forgive me, with this Act. I think it is fit for purpose. I think it is good law. I think it is misunderstood. You will all know this when I say underfunded. It is misapplied. And there is still, for reasons I do not understand why, a fear of applying it properly. And there's a lack of bravery. You know, we have law, let's use it and use it effectively. And I think there is, particularly, we have become so, you can't prosecute unless you have a victim. And I'm sorry, I disagree with that. A victim doesn't have to come to court to give an account. There are other ways and means of effectively safeguarding the victim, properly prosecuting fairly, and ensuring that we disrupt organised crime groups. But that needs resources, and that's often going down the financial avenue because, as you will all be aware, that forced and compulsory labour, slavery, all of those offences are driven by greed. So forgive me for using the vernacular, you follow the Al Capone, follow the money. And that is a problem. So Section 45, I think, works in the main. But often we see, and I've had a case come across my desk just yesterday, where a young woman in Hull gave a very detailed account of who was exploiting her. She'd been cuckooed. What was happening? All of this was done, may I say, fantastically by Humberside Police, who interviewed her. But she's been rejected from the NRM because nobody gave the NRM the full details of what she'd said in an interview, and nobody spoke to her. Well, how can that be appropriate? How can that be proper procedure? And so everything is there. It's lack of understanding, it's misinformation, it's lack of resources. But if we tie those all together, we can go back to where we were.
as you say, it's a financial crime. It is not. It's a coercive crime, but it's ultimately financial.
Yes, it's driven by greed.
And I think the confusion that it is an immigration crime. Your immigration status makes you vulnerable, but it's not an immigration crime, and that's where there's the fact that the directorates sit together, organised immigration crime and human trafficking, the fact that it was sitting in the Home Office underneath the Immigration Minister has meant for that confusion.
Absolutely. If we look at the NRM statistics, the second highest people in the NRM are British nationals. How is this an immigration crime? And deploying it as a political weapon under that is simply wrong.
Robbie Moore.
No, that's my question. Question done. So. Oh, sorry.
I'm so sorry.
No, not at all. Sorry. That was that section done. Sorry. I was that engrossed in what you were saying. It was very good. Moving on to identification processes. How well do individuals understand the national referral mechanism process, and what does this mean to be referred to a potential victim of modern slavery? I don't know. Emma, do you want to?
Yeah, I was going to go back to a point that you made actually about that not sharing of information, because I think there is a real gap. Quite a lot of people understand their duty to refer. A lot of people don't as well, but a lot of people do and are willing to enter into that process. But there are definitely gaps around that understanding of the need to update and the need to provide further information. And I think because we work in a sector where there's quite a lot of move around of professionals, it might be that the police officer or the social worker, whoever submitted the NRM first of all, doesn't remain with, in our case, the child. And so there's a bit of a lack of understanding about who to go back to for further information. We work a lot with professionals, helping them remember and put together further information to send through to the SCA, helping them to understand what is useful, what isn't, what needs to be included and sent through to inform that decision making. But there's certainly, I feel, a kind of a little bit of a gap in terms of that understanding of that ongoing requirement to kind of submit information through the process. There's also an issue about transition at 18. Obviously, for children, they don't need to consent to be entered into the NRM. It's always good practice to talk to them about it, to help them understand that system and process that they are involved with. But that unfortunately doesn't always happen, and what that quite often means is as a young person approaches 18, people are rushing to have that conversation with them. They might not understand or be willing to remain in it, and that consent is for a process that started when they were a child, so it's a bit of a misfit in that way. So I think that probably the two biggest issues for us are understanding of the full process and that point of transition. We deliver sort of online training sessions that are free every few weeks. We have them, and we get a really good attendance at those. People are really interested. They've got an appetite to learn. We've recently developed those, so they are, what is the NRM? Let's start with the basics, and then how you work within that process in terms of what you need to do to perform your role. And there's definitely an appetite for people to learn and understand, but I think that will always be there because of the move around in social care, police and other services in terms of staff.
Yeah, I think for us, high quality referrals are essential for a decision to be made, and we're seeing that those the information within a referral is lacking significantly, and that's something that we've raised on so many occasions. So that there is a lack of training and understanding of what needs to be put into the NRM. So to hear that maybe a victim wasn't even spoken to and yet a referral was made is very worrying, because the whole aspect of somebody sharing their story is key to gathering that information and being able to do it in a trauma-informed way. So within the Salvation Army, we've offered and give training to so many of the statutory bodies because they don't and haven't known what to do and how to do it. But then we receive referrals that aren't complete, and we have to go back to the victim, and then they have to share their story again. So that's again more trauma for them, and we gather that story and then we're able to submit it. So training is key. Funding, as has already been mentioned, is another key area because the role of the first responder and organisation is self-funded. Interpretation, that is key. We had a victim who came to us who had already been submitted into the NRM. There wasn't enough evidence to give her a positive RG, so she was she was released, and she was re-trafficked. The reason being is, in the first instance, she couldn't speak English, and the FR wasn't able to gather the evidence required. So she came through again, and this time had a positive RG. But it's not good that happens. So training, funding, and support to get the information is crucial.
How has, I know it was briefly mentioned earlier on, but County Lyons, how, or if any, has that impacted workload for both of you in terms of the complexities associated with that, and even victims understanding their access to the support that they're able to get?
I mean, for us, every victim is taken on their own merit. So somebody who's a victim of County Lyons and somebody who's a victim of some other form of exploitation will be, supported in exactly the same way. In relation to County Lyons, the difficulty that some of our adult victims will experience is when they're actually leaving the system because leaving the support that we offer them because of the lack of local connection and its housing. We have somebody in our support now who's received a positive CG, has been receiving support for his mental health, for his substance misuse, and is in a really good place to move on, but is actually now really anxious because housing is a real issue for him.
Okay, thank you.
Right, did you want to come in?
Thank you, if I may. The key part for us in the criminal justice system is the consistency of approach in the NRM. But of course, it's an interview process. But as has been quite properly identified by Emma and Cathy, the people who are conducting the interviews aren't trained to the degree that we require them to be trained in order to be trauma-informed when they're asking questions. Even now, when I'm obtaining accounts from victims or directing an officer to do so, we advise about the achieving best evidence. It is all about understanding the victim's specific needs. We talk in the police system of doing an ABE, video recorded evidence. Actually, many of the victims complainants would rather give an account in a Section 9 statement. They don't want special measures because they want to confront their perpetrators. But there is a complete lack of consistency in obtaining accounts across the board. And it is, again, going back to basics. Education, information, and bringing everyone... We're all on the same page, but we're just reading it at different speeds. And we're not getting everyone to apply the standards consistently to ensure that Cathy and Emma's approach is being adopted. And that's where we're failing.
Murray.
Thank you, Chair. So we had, just while we're talking about FROs there, we had the Home Secretary before us in December, and what she said was the NRM system has fundamentally become a bit stuck. And I want to ask what you think drives that. We haven't updated the list of first responders since the Act came in. Do you think it merits revision? Or when you're talking about the ability of first responders to properly complete NRMs, what have you seen that either drives improvements in that or that drives sort of it not working?
Cathy, do you want to start on that?
So we've, for the last 7 years, we've been constantly pushing for a review of the FR system and the FRO role of the FRO, because it's working to a point, but not as well as it could be. So I've identified training already, but what we want to see is that the information that somebody is sharing is captured in a better way. So we've been involved in the new online system. So we've been able to inform how that could be improved. What we have found in the last probably 2 or 3 years, that all of our comments and recommendations have not been listened to, or nothing's happened basically. So we're really pleased that we've now been invited to a FR working group. So a forum is being re-established. They were in place a while back, but everything just stopped. So we're pleased that's now happening, because it's important to understand what needs to be captured within the interview when somebody is sharing their detail of what's happened.
And I would agree. We're also really pleased to hear the First Responders Forum is returning. I think that's a real positive. I think for us, training, again, is what we've said is really important. We've seen real positives, like I say, come out of the devolved panels, and we'd be really keen to see that kind of expanded, I think. Again, it's that those who know each other working together really effectively, obviously in the best interest of the child, but having the knowledge at their fingertips, being able to call on it there in the meeting, being able to kind of engage with local partners to understand what's really happening for a child and that child's family. I think what we've seen in those settings is health make a really positive contribution to those panels, and I think certainly there are instances where trafficking victims, it might only be a health professional that is the person that they see or that they might talk to about what's happened to them. So certainly a consideration around whether or not it's appropriate for health partners to be involved in first responding, I think would be something to consider.
I agree with everything that's been said. I go back a bit further, and I think part of the problem is in the actual process itself. It's natural, because my job is to ask questions. That's what I'm trained to do. That's what the police are trained to do when they are specifically trained to be interview officers. But first responders are not given that same type of training to understand why their questions and how they are framed matter. So some of the questions are inconsistently put. There are obvious problems that we see when we get an NRM interview where they are closed questions. And it's something as basic as, can you explain to me, how did you come to be in this environment? Simplifying that, how do you know Robbie, the person who's exploiting you? And by having much more open questions, you are inviting the person who's making the application to give their story in full. The closed questions actually cut off the account. And that is a primary problem of training. And I don't mean it critically, I just mean it's an actual fact that we have to then deal with inconsistent accounts in an NRM to that taken by the police when they're asking opened and informed questions.
So just to be clear, you're saying that it's the training of existing first responder officers that's the issue, not that you'd like to see more first responders, organisations. You kind of alluded to the health system there.
Is it a bit of both?
I think it is a bit of both.
Yeah.
I can't comment on whether we need more first responders because I'm too far down the chain, forgive me. But when I get a first responder account, and when I'm prosecuting a case, disclosure requires me to look at the entire NRM file. It creates a disclosure nightmare for us because what we see are accounts inconsistent in the NRM process to that being given to the police. And it's not a deliberate inconsistency on the part of the complainant, victim, applicant. It's simply that the questions asked have narrowed the account. And that creates a credibility issue, which is not fair, frankly. And actually, if you open the question, keep the question who, what, why, where, when, an account that is more capable of credibility assessment is obtained. A proper, honest credibility assessment is obtained. Because we have to recognise not everyone who goes into the NRM wants to pursue a criminal allegation.
Yeah, absolutely. So just a little bit about the decision waiting times, which have obviously increased massively in recent years. I suppose, firstly, what's your assessment of why those waiting times have got so bad? And secondly, what would your what's your remediation that you'd propose? Is it just more decision makers we need to do, or is there a more structural issue in the NRM? So,
I mean, we were very pleased when the new 200 decision makers came into post in January. So that was a really welcome development. We haven't yet noticed as such that the decision making for those that have been in our service the longest is becoming apparent, because we would like to see that they are the ones that those decisions are looked at. So we don't know the criteria of the decision makers, but we are pleased that they're there. We are also aware that it's been great that there's been a 40% reduction since they've come into role. But of those, 70% have had to be reconsidered, or they've been overturned, they've been reconsidered, and they've now become positive, which also then demonstrates the fact that the information for those decision makers isn't adequate. So, you know, does that then go back to that first responder role and the information that's in the NRM, because it's not adequate? So there's kind of a full circle potentially. Sorry, what was the other part of your question?
So what would you do about it? Is it just more decision makers?
Well, no. I mean, I think if the people who are in the service longest were prioritised, it would certainly help. And if we had an understanding of maybe the criteria and what the decision makers use to help them to help inform their decision making, would be helpful as well. Because the people we support, they say to us that their life is on hold, so they can't move on, they can't progress. They're wanting to to move on and develop and to move out of this situation, and they can't. And it would just help if they're able to.
You already mentioned the devolved decision-making pilot. Do you think that offers lessons on how we can improve the quality of decisions as well as the speed?
I think that's what we're seeing. I think the evaluations kind of pointed to really positive kind of workings and outcomes from those meetings. So I definitely think it's demonstrating a different and a positive way of kind of moving through systems. Yeah. So I think if you can get that local commitment and buy-in, you're working with people who have that connection to the young people that they're kind of looking at and considering, and they're directly able to make sure that the safeguarding response matches up with the decisions that are being made. So I think for connectivity and collaboration, it's a real positive, yeah.
And actually, it's a brilliant question because it floats back onto the Section 45 issue. One of the problems that we have with the Section 45 process is the starting point is, if you're going to raise the defence of I've been compelled into this criminality as a result of being a victim of trafficking and exploitation, the starting point is getting an NRM decision and getting a conclusive grounds decision. And so I wonder, and this is purely through my criminal justice lens and no other, whether we expedite those or prioritise those who are in the criminal justice system and they are pushed up the line. But I wouldn't want to do that to the disadvantage of those who've been waiting for months and months. But actually, that whole starting point is very relevant in the criminal justice system because that's where representations are then subsequently made to the Crown Prosecution Service that this is a case that shouldn't be prosecuted for public interest reasons, or because we can evidentially demonstrate that someone is a true victim under Section 45.
But to be absolutely clear, nobody can self-refer into the NRM.
No.
So it is absolutely the case that they have to go to a first responder,
yes,
and the first responder has to do the mechanism. Because I think there was a little bit of a myth growing that people just claimed they were victims of modern slavery and abused the system.
It doesn't work like that. And don't get me wrong, in the criminal justice system people lie. But people also tell the truth, and people lie for many reasons. But there will always be someone who abuses a system, any system. But more often than not, people aren't. And it's the true victims that we need to identify and protect, irrespective of where they come from, how they've been abused, or what has happened to them. If they are a victim of exploitation, they deserve our compassion.
Thank you. Joni Reid.
Thank you. I just want to turn now to the quality of the support, the engagement support that victims has once they're in the system. Could you just begin by giving us an idea of how you engage with different cohorts of people once they are in the system?
Yeah. So we can work with children before they're referred into the NRM if it's looking like that is something that's going to happen for them, and we're really lucky in that our team is set up. We're flexible, we're all home based, so we can get out to see children very, very quickly if we need to. We have a guardianship assessment team who assess all our referrals, so we're able to kind of offer professional advice really quickly, and we offer on-call advice as well, so we're able to respond very quickly when a child is identified. In terms of accessing support through our service, if a child has someone with parental responsibility in the UK, we work with the professional network to make sure that they understand the exploitation of the child and they're putting appropriate safeguarding and risk management strategies in place. And we offer direct support for children where they don't have someone with parental responsibility in the UK, and that support is very much tailored to the needs of the child. So many of those children will be looked after by the local authority. We're working alongside other professionals, coming alongside them to help them understand that child's experiences and respond as appropriately to them. So our work really varies depending on where the child is at the time they come into our service. Again, it's that trauma-informed approach, making sure that we're working alongside interpreters and colleagues that are providing their accommodation, their social care support to meet their needs at all times. We work really hard to make sure children understand their rights in the UK and the breadth of services and of support they're entitled to. We make sure that they link in with independent advocates so that their needs are met as well. So it's a real kind of a collaborative approach to supporting children and young people. We do a lot of work supporting young people talk about their experiences, what has happened to them in a safe way, and explaining to them that unfortunately they're probably going to have to talk about that again in the asylum system when they're talking to social care and others. So it's that kind of nurturing one-to-one support that we offer to young people that hopefully helps them kind of move forward and kind of grow and develop in the UK.
I think for our service, the providers that we have across England and Wales are very good at working with other agencies in the areas that they support the clients that they have. And it, depending on where they are, will depend on the kind of multi-agency support that's available. So there are partnerships, multi-agency partnerships, across some of England and Wales that work together, and our support workers are able to link into that and to gain the support for our survivors. But it's not consistent across, and that's one of the concerns. So, mental health is one of the key areas that our client group needs support with, as with legal aid as well. And it's just so, it's so difficult to access that in many ways. So our victims aren't getting the support that they are entitled to. So again, the local connection is an issue. In one of our pilots, in one of our areas in London, we have a pilot, trusted assessor pilot, where 3 of the local London boroughs are working together, and our support worker has been given the role of being the trusted assessor, so they can fill out the application form for housing, and they work very closely with the local authorities, and we'd like to see that kind of a support across other local authority areas, but it just depends on the local authority and other.
This theme of inconsistency is coming up quite a lot. Yeah. So what do you think the government could do at kind of central level to ensure that we're listening to victims and meeting their needs more effectively?
Well, again, it's this kind of cross-department working, understanding the issues and the needs of victims of modern slavery who have got specific needs, and trying to, just trying to see how that can work across. So, mental health, NHS, the fact that it's been identified that we should have some sort of health first responder is important, but just to get some connection across the departments in supporting people who need specifically mental health support, really, because of what the individual has been through.
I think as well for children, mental health support absolutely is really, really important, and understanding that people will be working with children who maybe aren't used to thinking about Western structures of mental health support. But I think perhaps for children as well, it's thinking about what they might need later, because obviously we're working with children quite often in crisis who do settle and things kind of move on for them, but it actually might not be until they're an adult that they're ready to engage with that support. So there is something about that longer term perspective for children and adults, really, in terms of their experiences.
Once they are in the system, do you think victims are safe from any risk of further exploitation? And how
No, we're talking about extra-familiar harm in most of these situations, and I think it's very hard to fully safeguard, in the best will of the world against everything. I think professionals work really, really hard to put strong risk management and safeguarding strategies in place around children, but we're talking about a group of people who are operating around us and making money from individuals. So putting all of the safeguards in place is very, very difficult. We see some young people who are trafficked into the UK but are then exploited through more of a County Lyons type model of exploitation. We're working with people who are very vulnerable, who are potentially going to be targeted by these people again and again, and I think that's very, very difficult. But there is lots of hope as well. We have lots of positive outcomes for children, young people. We see young people go on and achieve. I think one of the biggest risks for all young people in the care system as well is that change at 18. The shift from children's to adult services is a really difficult one for any child in that system and process, regardless of whether they are new to the UK or they've always lived in the UK. And I think that kind of managing that transition really effectively, whether it's between children's and adults trafficking services or children's and adult services more generally, is really, really important.
We find that, I support everything that Emma has said, and we find that for some of our adults, the time that they need to really, reflect and recover is really important, because some haven't realised and appreciated that they have actually been exploited, and they're embarrassed to admit it as well. So they need time just to reflect on that. And the needs of some of our client group are very different. So we have professional people we are supporting, medical professions, others who are well educated but have been offered something that hasn't then come to fruition, and they're wanting to work, they're wanting to be able to continue to provide. So the opportunity for them to work isn't always there, especially if they're foreign nationals. So to enable somebody to have that opportunity during the time that they're with us, so to give them sort of leave to remain for a year, to enable them to have access to public funds, to really continue to grow their confidence and regain that ability to continue with their life would be so good, to support them and to help them understand what has happened, and then to hopefully prevent that risk of re-trafficking.
Can I like to turn now just quickly to legal aid? The problems with it are well documented. Is that the case in this sphere as well?
Yes. I mean, when they come into my realm, legal aid doesn't apply because they're brought effectively into the system because they've made a complaint, and the police, Crown Prosecution Service have drawn the conclusion that there is an evidential case to answer and a public interest to pursue the case. I know from the fallout of over the 1,000 victims that have traversed through my small world that gaining access to criminal injuries compensation, gaining access to basic rights, nearly every victim, in fact every single victim I have had in the last 13 years has come to the UK or been in the UK and seeking to work when they have been exploited. These are not people who are looking to live off the state, but they're exploited because they've wanted to work and someone has taken advantage of that desire. But their access and understanding of what they're entitled to, it is actually one of the means by which they're exploited. But when they come out of the initial exploitation, they don't understand what is available to them. And an example is there were some, I hope I'm giving the right nationality, Lithuanian chicken farmers. So they're chicken catchers, and there wasn't a case to prosecute deemed by Kent Police, but only because they went to a free legal advice centre run by, I think, by Hogan's law firm, did the case go to the civil courts and they were given compensation. So it's actually understanding that you may be cut off at the criminal end because it's a different criteria, but understanding that there are other avenues of recourse is a major problem. And if I may, can I turn back to the issue raised by my colleagues just now? One of the things that we see is the full rate of attrition in the criminal justice system. Victims not wanting to continue being victims, and the single biggest game changer for us are victim navigators. They are a single point of contact that quite literally navigates the criminal justice system without compromising disclosure, without compromising my independent role, because I shouldn't really have any involvement with the victim, save or complainant, save when I meet them to give evidence. They act as a liaison between the police and a filter and an understanding where, for example, victim services can't intervene. And the other problem that we have is a lack of cultural understanding. When we talk about victims going back into exploitation, irrespective of their cultural identity, there is a natural inclination to go back to what you know. I want to go back to the people who spoke my language. I wanted to go back to the people, as happened in our Vietnamese case, to the people who fed me noodles. Yeah. And it doesn't matter the ethnicity, the socioeconomic background, or the gender, because exploitation is blind to all of that. Horrifyingly, in every case that I have ever prosecuted in modern slavery, there has been a female on the indictment in a senior role. And there are probably more women in prison as a result of modern slavery and exploitation offending than nearly any other category, which is something that we don't often tend to recognise, and in the exploitation of males. So, this is a gender-blind offending. But what we see is victims, irrespective of age, returning to what they know best because, as has been identified by my colleagues, I don't know that I'm a victim. I'm ashamed that I'm a victim. I have let myself down by being a victim. Or psychologically, I haven't got through the process to understand that I am a victim.
Could I add to that as well, fear and control for those who are exploited through criminal exploitation?
Absolutely.
That is a very real threat for a lot of children.
It is a huge threat. And what we're seeing is bolt-on offending now. In the case of Mugambi, that's just happened in Oxford, one of the offences put on the end of the indictment was witness intimidation, because there is a overarching prevailing fear that this will be reperpetrated on them by those offenders.
Or on their families, or
absolutely.
Their siblings.
On the back of an ID card, for example, from Poland, is the name and address of the owner's parents. And once that information is within the hands of the perpetrators, where does fear stop?
Even in the case of somebody who's a victim of county lines, we have a young lad who was rescued in the north of the country and brought down to the south because of the safety aspect, and he still can't go back there because although he's out of our service now and has had to re-establish a life, but can't really contact his family back home where he would call home because of the fear of the gangs and the perpetrators that will just either cause him problems or his family.
And it is a real and legitimate fear. And I say that from the criminal justice system. And it is something that the police are trying really hard to deal with, but it adds a very different dynamic when investigating the criminal activity of exploitation.
We don't have the systems there to deal with it.
We have the legislation. We've got witness intimidation, but we simply don't have the capacity to deal with it. You're so right. And I think what people forget when we look at Section 45, and I'm returning back to what you asked about earlier, the hat moves. When the CPS and the police investigate a case, they're looking at it from a linear perspective. That's their job. Somebody's dead. Who died? How did they die? Who did it? With modern slavery and exploitation, you have to stand back and look at it from a macro picture. And the person who could be the perpetrator may have been a victim and may still be a victim. And the minute someone raises exploitation, they then become a prosecutor on behalf of the victim, who may be a defendant also. So it's a really unusual and complex dynamic that, in fairness to the police, they're working really hard to unpick. But education, information, consistency and resource.
Just turning again to Section 45, you outlined right at the beginning about the problems and agreed with Karen about the crime and policing bill. Can I infer from that then that you think that the protections for children set out in 45 are adequate?
I think the law is good. I think its application is where we have problems.
So you've already, that's clear, thank you. And just finally from me, do you think the legislation in and of itself gets the balance right between providing protection for the victims and enabling prosecution, or would...
Properly deployed?
Properly.
Yes.
Okay, that's a clear theme. Thank you very much for your time.
I mean, I think just the very fact that somebody has to admit to themselves to being a victim is an incredible step for any individual to take. And particularly if they have, as a result of being a victim, become a perpetrator themselves, that is, and their immigration status is uncertain and all these other things.
Absolutely.
It's a very, very difficult and complex thing.
It is. And what's been interesting from the criminal justice perspective is I have seen a growing awareness since the Modern Slavery Review, when we put the tick box on, have you asked whether someone is a victim of modern slavery? And what we are seeing is often well-informed and trained police are turning around and saying to people in interview, well, are you a victim of modern slavery? Talk me through this process. I refer back to the case in Hull, and having seen the independent report undertaken by an expert in that particular case, his distillation of the evidence was, actually the police have done an excellent job on this. They are pressing the right buttons, but there's been a lacuna between the appropriate parties to then take it to the next level. We find it with, and I don't mean this critically of my colleagues who are lawyers, solicitors aren't identifying it. My colleagues at the bar aren't identifying it. We all need to inform ourselves of what we should be looking for, but balancing that by not abusing the system. And it's rational, considered, measured, critical analysis of what evidence is before you.
We've got a few more questions for you, if that's okay. I realise we're getting close to time, but Margaret Mullane has some questions, particularly on prosecutions.
Thank you, Chair. Could I ask Caroline what she feels the main challenges are for you when you're investigating and prosecuting a very complex modern slavery case? And with that, how effective, you've mentioned some sort of cases earlier, how effective are law enforcement in supporting you?
Thank you. I'm really privileged to work in this field, and I am even more privileged that the Crown Prosecution Service frequently instruct me early on in proceedings, so I get to be the lawyer in the sweetie shop and say the evidence that I want. By and large, the police forces that I work with have come to me, or counsel, because they want to do this right. There is still a depth and breadth of knowledge about how this legislation works. And I say that across all tiers of the criminal justice system. Where we really struggle is with financial investigation. It's simply so complex. The current case that I have, we are dealing with cryptocurrency, we are dealing with money transfers from sterling to a foreign currency and back again, and what is the variation in the values. In one specific aspect of that case, over 65 bank accounts for one individual, in multiple jurisdictions. Now, with the greatest will in the world, I stopped maths at GCSE. So I need all the help I can get.
Yeah.
And some of it is being done really well. And there is an appetite in certain police forces and a real drive and desire to do this right. But when we stand back and look at it, so for example, in a sex trafficking case, I can prosecute sex trafficking from one venue to another for the purposes of sexual exploitation, and I can prosecute controlling prostitution. The maximum sentence for controlling prostitution is frankly pathetic in comparison to human trafficking, where the maximum sentence is life. So the appetite therefore diminishes because the core offending has the lower sentence, and the sentencing that will often be passed in these types of offences is fairly de minimis, actually, for the criminality that's taking place. I think there is a desire by all participants in the criminal justice system to do this right, but there is obviously a resource issue. A current case that I have at the moment 18 defendants. I could identify another 150. It's got 750 victims. With the greatest will in the world, and in deference to the British taxpayer, I include myself, we have to draw a line in the sand, and we have to be proportionate. But I also have a responsibility personally to 750 sex workers who have been exploited. Where do we find the balance? And that is challenging. And there are some police forces, frankly, who are significantly better at this than others, and some who are going into this for the first time. And I think Again, consistency, education, information sharing, understanding the resources available. I'm the one telling police forces, why aren't we using a victim navigator? Because they don't know about them, and they're so phenomenal. We know that the resources we've had from, example, the Salvation Army has been exceptional in Operation Fort. That was our starting point for managing all our victims, 350 of them. And there are some amazing charities out there doing amazing work, but simply, I don't think we work collaboratively enough in this sector. I don't think we realise what resources are available to us. But in the technical phase of the criminal justice system, we are under-resourced financially. By that I mean financial investigation. We struggle with consistency of approaches. In some cases I've got a team who get it. In some cases I simply don't, and it's spoon-feeding. I'm privileged enough to be instructed early on enough to do that, but I would hope that that was not necessary. We are getting results. I've said this before. Data collection and understanding from the Crown Prosecution Service is complex because, for example, if someone pleads to controlling prostitution as opposed to trafficking, that wouldn't be a Modern Slavery Act offence, and so it wouldn't be recognised as such. But actually it's the same form of exploitation, isn't it? And that's a kind of data gap that we're seeing. And so when you've got data gaps, you've got information gaps and knowledge gaps, and resourcing isn't appropriate. We are trying really hard, and I have yet to come across an officer who doesn't turn over the stone in this type of offending and get gripped by it and try and do the right thing. But it's really hard. And where I'm really struggling is a lack of information or inadvertent misinformation from government bodies. For example, in a recent case, I had a statement from the Home Office that was factually wrong in law, and it's my fault. I should have picked up on this. I'm counsel, that's my job. But I nearly didn't until it was too late. And it wasn't deliberate, quite the opposite. This was all done in good faith. But there is a real lack of understanding and a real lack of information sharing, and a single point of contact in each government office, exactly like my colleagues are saying here in local authority, would make a really big difference.
And my last question is, how are you working with international partners to share best practice with prosecutions?
Yes, we are. There is an organisation that I'm privileged to be involved in called the Prosecutors Consortium, which runs with the McCain Institute and the Centre for Social Justice and Care, which we identified that there are other people out there like me, from Israel to Jordan to South America, all through South America, the Philippines, Bangladesh, Africa, and we meet every other month or every 3 months, and we talk about case law and how we can do better. And at the moment we are looking at definitions as an organisation, what works best for us. We're looking at how you can do victimless prosecutions. Last Wednesday we gave a lecture to the International Prosecutors Organisation as the group of us that we are, and we're all specialists. I'm very privileged that Lynette Woodrow from the CPS is also involved. I've got a colleague from Ireland. We are a collective of individuals. I'm the only one in independent practice, obviously, because of the way our process works. But we share, and there is a very active WhatsApp group which shares case law and issues, and we talk about bilateral agreements. There's a bilateral agreement between Nigeria and Italy, and we've discussed about doing something similar here. And interestingly, there is a similar bilateral agreement between Romania and England, and the UK. So there is international best practice, or there's an aspiration to international best practice. There is certainly information sharing. It's a small community. We kind of know who each other is. And we're all on the same page, trying to do the right thing. So yes, it's not inexpensive, our gatherings, even though they're online. We have to show the purpose of them. What's the outcome? And so we're at the moment trying to find new funding to show, actually, this is what we're doing. We want to make representations to the UN about definitions. We have been working with Baroness May to try and assist her in her work in this sphere as well. So yes, international sharing. And we have JITs. We may be out of Europe, but there is still international policing. I've got 3 JITs running at the moment, joint in investigations. I have, without fail, learnt enormously from my colleagues around the world in this sphere.
Thank you.
Mary.
Can I just very quickly come in on that point, because obviously the NRM is UK-wide, and it's a UK Act of Parliament, but in Scotland it's the Modern Slavery and Human Trafficking and Exploitation Act 2016.
Yes.
So I just wondered if any, I know that Salvation Army, I don't think you do have the contract in Scotland, is that right? So do you have any reflections on the difference between how it works between Scotland and England, and any reflections at all?
Would you like to go first, or?
No, do you want to?
Yeah, I mean, it is very different. We don't have a contract. Migrant Help, Tara, and others, operate it from there. I would probably say the difficulties we have is identifying the victims that are victims of modern slavery. I say we, that the groups up there, so that they can actually access that support, and then the support that's available. So the kind of support that we offer within safe houses and others isn't as widespread. So it's more sort of temporary accommodation, outreach support that's available. So it is different, and to try and gather that information, I would say is difficult up in Scotland.
Obviously there's a separate service for children in Scotland, so I think we work in quite similar ways, and we do connect, and we do kind of link up, but it's a separate service.
What you always hear from providers in Scotland when it comes to children is they say it's kind of hard to explain to service providers why children should be referred into the NRM in Scotland, because they don't get anything extra given what they would get through child protection. Do you agree with that, and do you think it applies UK-wide?
I don't agree with it necessarily, no. I mean, I think it's something that is said, I think, to us as well, that there's a perception that children don't get anything.
Even down here?
But I think they're entitled to access support through the ICTY service, through the guardianship service in Scotland, and I think there is definitely, obviously I would think there is a role for our service. I think where we can kind of, the two services can kind of do is bring professionals together to make sure children are getting their needs met. So I think it's about that recognition as a victim, that understanding of their needs through that process, and that need to kind of safeguard and manage risk around them.
Caroline, it's the Crown Office in Scotland to do the prosecution, so do you have a view on that?
There's been a notable vacuum in prosecutions in Scotland, and I wonder if that is because, now I don't practice in Scotland, but I have advised on cases in Scotland. I wonder if part of that is a lack of understanding about robust investigation and understanding that, honestly, each area has its own nuance of exploitation. An area that I particularly see in Scotland is in trawlers. Peterhead and the whole Aberdeenshire coast, for example. And there is a real need, I think, there was a case obviously last year, but there's a real need for understanding how the law can be applied, albeit in its nuanced difference. Looking at it from the child perspective, because there's child interveners in Scotland, that provides a very different way of managing children who fall into the criminal exploitation. And there's a lot to be said for that. But I don't think it would be appropriate as a non-practitioner to really comment any further.
And the trawler issue is also Northern Ireland as well, of
Absolutely.
course. Absolutely.
And it is a real problem, because if you are at sea, you can get lost very easily.
Absolutely, and that was, one of the reasons we put some of the changes into the law, which brings me on to my final question, which is what legislative and non-legislative changes might we push for as a committee? I'm thinking there's for example, in the Crime and Policing Bill, there is a suggested amendment to change the trafficking definition so that it's clear that it doesn't have to involve movement. We've also talked about financial assets, and is there anything there that we could do differently or we could work on? And have there been, subsequent to the Modern Slavery Act, any pieces of legislation that have hampered your work?
Perhaps I should go last, shall I? Defer to my colleagues.
I mean, I would like to see a review of the NRM. I think that sort of been a long time in coming, really, and the whole review as well of the FR role and that sort of gateway into the service and support that's offered.
We had the review of the NRM, I think 2016, wasn't it? And there hasn't been anything since.
No.
Yeah.
No.
At the moment, our service covers 2/3 of the local authorities in the UK, so obviously I would want it to be expanded across all of it. Obviously, we cover Wales, but all of England and Wales. And I do think that's kind of scope to look at the devolved NRM panels in a broader sense. They're not working for adults at the moment. Maybe that's something that could be looked at, but an extension of what's happening for children, we could definitely see some benefits there.
On the plus side, I think Sections 1 to 5 of the Modern Slavery Act are fit for purpose. I think the application, interpretation and education behind them are where we are failing. On a personal level, I would very much like to see the maximum sentence for controlling prostitution increased from 7 years, because it is an exploitative offence, and irrespective if it's online, in person, wherever, it does not reflect the gravamen of offending that we are seeing. And I have a real problem with that. I would like to see, in practical application, I'd like to see victim navigators rolled out nationally. As a participant in the criminal justice system, to me, they're a game changer. I would like to see, and I know that this is repeated ad nauseum, and I apologise to the Home Office for this, I would like to see financial investigating officers as a starting point in all modern slavery cases. I think it's really important because it's follow the money, it's agreed-driven offending. I would like to see on a macro level, and I keep pushing for this, and Madam Chairman, you have nailed it, if I may say so. Can we please distinguish properly the difference between trafficking and exploitation, Immigration Act offending and human smuggling? They are all very, very, very different things, and conflating them is just simply wrong and does an injustice to victims and does a disservice to us.
Thank you very much for your time. I'm sorry we've taken a little bit more time than we'd hoped to, but it's been absolutely fascinating, and we will move on to our next panel. I'm going to suspend for a few minutes so the panel can change over and breaks can be taken by those who may need them. But thank you again for coming in, and if we get our next panel in, that's wonderful. Thank you.
Oh, thank you very much.
Order, order. We'll resume our hearing now with our next panel. Absolutely delighted to have our two witnesses. Maybe you would like to introduce yourselves, starting with you, Eleanor.
Thank you for having me here today. I'm Eleanor Lyons and I'm the Independent Anti-Slavery Commissioner.
I'm Elizabeth Butler-Sloss. I'm an independent peer in the House of Lords. I was on the team with Frank Field that persuaded Theresa May to have a modern slavery bill, and I was on the pre-legislative scrutiny committee.
You gave me a very hard time when I was the minister, so I can vouch for that. And I promise I won't do the same in return. I'm going to start with the same question I asked the first panel. I know you were in for that, but that was the House of Lords report recently, the quote, "The world has changed and best practice has moved on." What do you see as the main causes of the change? Perhaps starting with you, Eleanor.
So I think things have changed in the last 10 years since the Modern Slavery Act was passed. In particular, the way that criminals are willing to ruthlessly exploit victims. We've seen a 5-fold increase in the number of victims who are being referred to the National Referral Mechanism. We've seen more children being exploited, more women and girls being exploited, and even between 2023 and 2024, a kind of massive increase in labour exploitation in these figures. I think for me, sadly, what's not changed, and what was clear from the last panel, is we haven't seen criminal justice outcomes improve in the last 10 years. So we've seen the number of victims being exploited increase, but not the same attention paid to actually making sure that we're going after the perpetrators of this horrendous crime. And I think, sadly, that has been one of the driving factors in seeing this kind of increased prevalence in modern slavery.
Elizabeth.
I'm, if you would allow me, particularly concerned about the legislation passed since the Act. As far as I can see, the Act has been totally pushed to one side by the Nationality and Borders Act of 2022, the Illegal Migration Act of 2023, and the Rwanda Act. And much to the credit of the current government, the Rwanda Act is not going to be implemented. And so far, sections, I think it is 22 to 29, the modern slavery part of the Illegal Migration Act, is not so far in force. I very much hope that your committee will say it should never be enforced. But what really concerns me are the sections of the Nationality and Border Act which are in force. And again, I would hope your committee would look at those sections, which are extremely concerning, because basically what's happening with, as your previous witnesses were saying, the conflation between immigration, refugees and victims. As a consequence, under the Nationality and Borders Act, if you come by any route which isn't by United Nations and possibly one other, you are a second-class citizen, and you start with a whole lot of disadvantages that was not in any way intended in the Modern Slavery Act. And as examples, there's, as I say, the conflation. There was, in 2019, 2020, excellent statutory guidance from the Home Office, and completely changed. I mean, you now have to show objectives. They've decreased the amount of recovery period. They expect you to give an answer within a short period, whereas the guidance set out the impact of trauma, the duty to give a proper, sensible explanation, easy for people to understand. And the fact is, it was understood in the statutory guidance that you might give, if you were a victim, a different account at different occasions, largely when you felt safe to be able to do it. And all of this has gone, and there are, under Section 65, it's narrowed the temporary leave to remain. Under Section 63, you lose protection if there's a threat to public order. Now, a threat to public order basically means, as I'm sure you all know, that you've committed criminal offences. But one of the defences under Section 45, which you've heard about earlier, is, of course, that you only did it under the duress of being exploited. But they're not recognising that under the way in which the Act is being applied. So basically, a great deal of the protection that was intended under the Modern Slavery Act has just gone out of the window. I find it extremely concerning. And I agree, I have to say, with everything that the Commissioner said and everything that was said by your first speakers.
Thank you. And, I mean, just let's ask the question. Is there abuse of the NRM and other protections for victims of slavery by those that are actually trying to claim asylum or are economic migrants?
In the Lords, I've asked, I think, at least 4 times, would the Minister, the last government, would the Minister give us any evidence of any example of someone who has abused the system? There have been, I think, half a dozen, but no minister has ever given us an example in the Lords.
I would echo that sentiment. I don't think we've seen any real evidence of misuse of the national referral mechanism. And I think from everything I've seen, visiting frontline organisations and charities and first responder organisations, that evidence isn't there. And if it is, it's certainly not widespread at all.
Certainly the OSCE, when I met them recently, were very keen to say that they simply don't see in any systems across the world abuse of protection services for victims of slavery. It's just not something that... It does at the margins, of course, but it's not widespread. Can I go to Robbie Moore?
Yeah, thank you, Chair. And I'm just keen to delve into the work of the Commission, if that's okay. And on the back of the strategy that was launched back in January, I was just wondering what interactions or discussions have you had with the Home Office or the government, and is there any indication of their response to it at the moment in terms of going forward?
So my strategic plan is one of the first things I did when I came into role at the start of last year. I consulted widely across the sector, visited local authorities, listened to those with lived experience of modern slavery too, and I submitted that to the Home Office last April. It was published this January, and since then I have been delivering for the last year against that strategic plan. I will say it's rightly ambitious and it's comprehensive, outlining actually what I heard from individuals about some of the challenges that they are facing in this space in terms of supporting victims, preventing exploitation in the first place, and also allowing for criminal justice outcomes for the victims. I have spoken to the Home Office about this strategic plan. I'm, of course, independent from them, so I operate in a separate office in a separate body, and I hope they can support me in that work. For me, the things that will make a main difference is I have rebuilt the office since having a large vacancy which I inherited and a dormant team, but I would very much appreciate more policy resource and more policy support in my office and my team to bolster it. And I hope they can also put kind of modern slavery back up the political and agenda and will. That has ebbed over the last decade, but I do think we now need this new government to create a modern slavery strategy, which is across government, cross department, and has clear outcomes of what we are now aiming for to help victims as we move forward.
And the strategy is rightly ambitious, as you say, and I know that you've obviously had that interaction with the Home Office, but have they given any indication of those reaching the ambitious goals that you've set quite rightly within the strategy from your discussions that you've had with them so far?
From my discussions that I've had with the Home Office, I think they are actually working in similar areas with the action plan that they are developing with the new minister in role. One area, though, that I think they really need to help me into and they need to work on themselves is how we really include survivor voice in the application of all our policy. So early last year, I submitted to the Home Office a business case for Survivor Advisory Council. I think that is an area that actually we really need to see come into fruition so that actually as we move forward, we are shaping our policy outcomes and understanding based on actually what victims have experienced. And actually I think that would make a very big difference in terms of my strategic plan and also the work of the Home Office too.
Okay, thank you.
Could I add something to this? Possibly a discordant note. But in 2019, Frank Field led a team of 3 of us to review the Modern Slavery Act. and one of the aspects of it was the position of the Commissioner. I've been on the advisory panel of the two previous commissioners. Not only, I have to say, was the current Commissioner not provided with anything like the sufficient support when she came in, but there was, as you probably know, I think it was 18 months gap between the two appointments. In our review in 2019, we recommended very strongly the Commissioner should not be have a line of whatever you call it, in relation to the Home Office, that the job of the Commissioner and the team of the Commissioner should actually be in a quite separate government department, preferably the number 10. And we were very concerned not only that the Home Office was extremely slow in responding to anything that the previous commissioners asked for. I would be surprised if the present Commissioner has had any better results. And quite simply, because the Home Office is main concern, as far as I can see, and my colleagues on all of these committees and reviews could see, particularly, I have to say, well, the House of Lords Select Committee, of which I was a member, that the Home Office is absolutely not the right place for the Commissioner, because the Home Office is concerned with immigration. And as we all know, I'm hugely to the credit of this government. Jess Phillips, as I understand it, is the safeguarding minister, has taken over. But there was a very long time when the immigration minister was in charge of modern slavery. And I think there is a concept in the Home Office, understandably, despite the modern slavery unit, of seeing everything through the eyes of immigration. And in the view of Frank Field and Maria Miller and myself in 2019, and I haven't changed my mind, the Commissioner should not be in the Home Office.
Thank you. Margaret Mullane.
Thank you, Chair. To Eleanor, you've said that you're ambitious, which is what's needed, but are you able to implement your strategy with your current staffing and your budget levels?
So, as been touched upon, I inherited a difficult legacy. I inherited a dormant office and a vacant position, and also, as Baroness Butler-Sloss has outlined, detrimental legislation was also on the statute book at that time. I have already been able to deliver against many parts of my strategy and worked across government, which has been something that's really important. I hope that I can carry on doing that for the next 2 years, but I would enjoy kind of an increased budget and an increased team that reflects what other commissioners have. So you obviously, if you benchmark across government looking at the Victims Commissioner, Domestic Abuse Commissioner or the Children's Commissioner, they do all have larger teams and larger offices supporting their work. And in my mind, preventing modern slavery and tackling human trafficking should have the same precedence as those commissioners and those teams do have. So ideally, I would like to see an increase in my team and my resourcing. But whilst there's the absence of that, I do actually pay testament to my current team who are working very hard to make sure we can do all we can within our powers.
So if that was an ask to this committee, that would be your ask, is resource. I know everybody says that, but that would be your...
That would be my personal ask, although I do have a lot more
I'm sure.
to put forward. Yeah.
Yes.
I think there some simple things as well of the Home Office that I would ask is, as I mentioned, the Survivor Advisory Council. More broadly, I think we need that strategy to come forward to outline how other departments are working on areas. And I think actually if we were to look at further legislation, mandatory human rights due diligence and getting other departments to play their part in tackling modern slavery is important.
Thank you.
Chris Murray.
Thank you, Chair. As we know, working on modern slavery in the UK can be a bit of an alphabet soup. You've got the UK Border Force, UKVI, GLAA, NCA, and that's just within the Home Office. Then you've got all the police forces, you've got local authorities, you've got devolved administrations. How effective are we at cross-government working in the UK, and where is there room for improvement?
Would you like to go first?
I'm just thinking I'm not really the right person to answer that. I've had very little to do with what happens in modern slavery outside England. I think a great deal has already been said, particularly by Caroline earlier, about the importance of government departments knowing what each other is doing, and also the issue of data, which is lacking. And I would hope it would be biological data rather than gender. But I really am not the right person to answer that question.
So for me, I think cross-government working is absolutely critical, because many of the levers that help victims' lives are not held by the Home Office, they're held by other government departments, whether that be local government with housing or DHSE with kind of like counselling, mental health support. I work across government with different government departments, with business and trade on the Fair Work Agency, on transparency in supply chains, with the Foreign Office, and I could go on to name more. I don't think at the moment there is effective cross-government working. When I speak to officials in those departments, they're often unaware of what other officials in other government departments are doing in similar spaces. I don't think there is any join up at official level, and also I think that is kind of echoed at ministerial level. An example where this has played out in recent years was in the adult social care crisis, where we saw actually a large influx in modern slavery and exploitation across that sector. And there was no single point of leadership in government at a ministerial level which took ownership for that. You had to go speak to 3 different ministers who all had 3 different briefs and were all tackling a slightly different part of the jigsaw. What I would like to see, and I think would make a change, is a re-establishment of an interministerial group in this area. That was the case 10 years ago. It makes a big difference. I think officials coming together also at their level and working across government departments would also make a tangible difference to victims' lives.
Okay, thank you. We hear a lot from the current government about tackling the exploitative gangs that traffic people and smuggle people across the channel. How effective is our work with international partners in tackling that, do you think?
So I think the government have done effective work in creating memorandums of understanding with different countries to try and work at kind of source to prevent individuals from being trafficked into this country. I will say, though, some of the rhetoric that comes from the government, the past government and this government, is unhelpful in terms of it trickles down to how willing victims are to come forward and speak about their experiences. So we still have the legacy of the Illegal Migration Act and the Rwanda Act. Even though some of those measures have been repealed in legislation, when you speak to victims on the ground, they're still scared. They don't understand that some of those things have now been taken away. I think when we're talking about tackling gangs or smashing gangs, we are beginning to conflate again people smuggling and human trafficking, and we're creating a climate of fear for victims. And I very much hope that there can be a clearer message from government about what they are doing to support victims of modern slavery.
So I want to ask some more questions about the identification process for victims and how we spot victims in the UK. What do you think is the most effective way of spotting victims for frontline first responder organisations, and how has that either improved or got worse in the last 10 years?
I don't know really, but dealing with children and identification, I remember going to a drop-in by Safe Passage, which is one of the excellent NGOs, and I'd been to Calais with Fiona McTaggart, then an MP, and we wrote a report basically on the children sleeping under the trees in Calais. And when I went from that, and Safe Passage organised it for us, and when I went to this drop-in centre in London, there were 2 boys there from Afghanistan. One had a moustache and the other had a beard, and they were both identifiably 16. So it does seem to me extraordinarily difficult how the current system, which has been put forward by the last government, of identification is ever going to explain the difference between an English or UK child who's very unlikely to get a beard at 16, but it's perfectly normal in certain countries. But how would that Afghan boy, he actually hitched a lift on the back of a lorry And that's how he got to London. And then he walked very sensibly into a police station. But, you know, I think identification is absolutely inadequate at the moment. But the other point, I think, is you.
So I think it is worth paying testament to first responder organisations who actually do amazing work, and we did identify in this country over 19,000 victims of modern slavery last year alone. Whilst that is alarming because the large numbers, actually I think it shows how much of a difference first responder organisations do make in identifying vulnerable victims. For me, this gateway really matters about how someone enters into the national referral mechanism. It's a moment when they're interacting with a victim at a particularly vulnerable moment in the victim's journey. And what I hear from victims is quite often this process isn't explained to them. They don't understand what they're entering into. And it's quite a confusing, difficult time. One area that I find particularly worrying is actually the inconsistency across first responder organisations. And I think that's best played out in last year's statistics on the national referral mechanism. So the majority of referrals came from Home Office and government organisations. And if a victim was referred in through that route, the chance of them getting a positive conclusive grounds was around 35%. Whereas far fewer victims were referred in by NGOs in the third sector. But if you were referred in by an NGO or someone like the Salvation Army who was speaking earlier, the chance of that victim receiving a positive conclusive grounds is around 68%. Actually, that shouldn't be the case. It should be whoever identifies you and wherever you are identified, you receive the same support and the same structure from any first responder organisation, and you have the fairest outcome at the end of it. For me, there's quite a simple solution here, which is there should be universal training across first responder organisations so that they all understand what their role is, what their responsibilities are. And that is something that I called for since entering into role and is also in my strategic plan.
Could I add something about the NRM? I'd just like to pick up what was said earlier. I think it really is time in 2025 that the MRM has a review, because the delays, particularly I think between reasonable grounds and positive grounds, has become enormous. And there was an interesting suggestion by a senior civil servant to do a dramatic change in how the NRM worked, but it was unworkable and wasn't pursued, and nothing has happened since then.
Robbie Moore.
Yeah, thank you. I suppose just following on the same theme, we understand the government will be announcing further indications of how they're wanting to change the identification process before summer recess. And I was just wondering, how confident are you that the consultation that the government has undertaken is going to result in changes that you would be wanting to see with that, with the identification?
Yeah. So I welcome the Home Office looking at the national referral mechanism. I think it's right that we ask, is it working for all victims? Who is being referred into the mechanism, and how are they being identified? As we've touched upon, there are some current issues despite the good work that is going on. I think it's really important, though, that this consultation is done in a timely fashion. And consultations, of course, by their very nature, take quite a long period of time, and then they are lengthy to implement those changes. I don't want that consultation to be at the expense of action happening now. So I do want that kind of first responder training to be rolled out universally whilst they are asking the questions in the consultation about what's the longer term plan for the national referral mechanism. But I will continue to work with the Home Office on it.
Do you think the government are asking, or the Home Office are asking, the right questions or the right indications of direction even through the consultation that they're doing?
So I've only seen the draft form of the consultation, which I think is still being developed, and they are still trying to work out which questions are those ones to ask. So it's difficult for me to give a full opinion till it's launched. I hope, though, that when they do launch it, they think carefully about how they are going to include survivors in that consultation process. And I think that's one area in particular that does need to be worked on.
And maybe you both may want to comment on this as well, is just what do you feel the cost implications will be of changing the identification process as well?
The financial cost implications.
Yeah, or beyond that, actually, social, but start with finance. But.
You want to go, Baroness?
Well, I'm just thinking about it. I mean, I don't understand finance, I have to answer. Also, as was said by Caroline, I gave up maths at the age of 16, and actually 14, but I can't see in principle why it should be more expensive, because the delays that are so enormous must be very costly. So if you could hurry it up, it may be that you would have to have more people doing the work, but if the delays are by then, I would have thought it was, a balance between them. But what I think is important is to look at how the victim survivors are being looked after during the period between referral and a positive decision. And also, I think it's important that the consultation should look at what should happen after the positive decision, because basically they're abandoned after the positive decision. Almost everyone, as far as I know, is abandoned. And that's a very unsatisfactory thing. They've been identified as a victim. Is that a good moment for this country, who's taken the trouble to find that out, just then to leave them?
So I think when we look at the current identification system, there are challenges in place. But as I've mentioned, I actually do think we are doing, on the whole, a good job of identifying a lot of victims who need support and care. One of my concerns about the potential impact of looking at the identification system is that we lose the good that is there at the moment, and we introduce a new system which, again, as we've touched upon, needs to be applied. We need to train first responders on how to utilise a new system. I would also want all victims to have the same opportunity to access equal care. If we start splitting out victim groups into receiving different support structures, I would find that myself quite challenging. These are all things that actually I'm sure the Home Office are looking at and considering as part of the consultation. But that is my nervousness in opening up this kind of topic of what should the NRM look like as we move forward into the future, and what should the identification process be, that we actually make sure that we're not making it worse, we're making it better.
Thank you.
Absolutely.
Thank you.
Ms. Murray.
Thank you. Obviously, victims of trafficking is a very heterogeneous group. You've got young and old, male, female, sexual exploitation, labour exploitation. But can you...
And babies.
And babies, absolutely, in all parts of the country, and all nationalities, including British. But what I'm trying to get a sense from you of what good support looks like. Can you either tell us some key indicators, or even better, an example of what you think good support would look like in the constraints that we have today?
Well, first of all, they have to live somewhere.
Right.
So you need accommodation. Almost everyone, as far as I understand, and I've discussed it with some psychiatrists who do this work, they need mental health help. And, I mean, not just at counselling level. Many of them have had a trauma, very serious trauma, as a result of years of being exploited. So I think mental health, housing, obviously enough money to live on, at least some from universal credit. I would have thought that government should be brave enough to look to see whether some of these people, particularly those who are educated and particularly who've been doctors and nurses in their own place, it would actually it would be of value to the country, our country, if they were put to work. And they all want to work. And there are other people who are electricians, who are plumbers, who have had all sorts of training. And at the moment, there is an absolute strong objection to allowing anyone who comes to this country, particularly who've been victims, to be allowed to go out there and help support the country by earning their living and doing some work.
For For me, good support looks like wrapping care around that victim and recognising that each victim has had their own different journey of exploitation. I think advocacy is really important, and we do actually have examples of good advocacy which is available in different parts of the country, whether that be independent child trafficking guardians, whether that be victim navigators, independent modern slavery advocates. We do have fantastic examples of this support. The difficulty is it not being universally applied in every area of the country, and I think that is a challenge. For me, good support is also timely and doesn't trap victims in limbo. 831 days for the average conclusive grounds waiting time last year is obviously too long, and I've met victims who've been in the system for 4 years without having a decision made, and I think that is a particular worry. I think also good support is consistent. As was mentioned by the last panel, there's been a massive increase in the number of reconsiderations. So a victim waits a very long time for a conclusive grounds decision. Then actually they're getting a negative decision. They drop out of care and support, only for that to be overturned and to be found to be inaccurate. And that happened to 68% of conclusive grounds decisions which were challenged last year, which is quite large scale when you think about it and the impact on victims' lives. So for me, those things and that kind of advocacy, that timely decision-making and that consistent decision-making, which is kind of multi-agency as well, ideally, in the advocacy and support that's provided, is what I would like to see in every part of the country.
Could I add something to that? Under Section 48 of the Modern Slavery Act, there were child advocates. So far, all 10 years later, there are only still pilots in some parts of the country, but they are absolutely invaluable to the children from overseas, and there are still lots of children from overseas. And in some cases, they can actually be helpful for children in this country, where there are problems with local authorities. And the child advocates have never been put out across the whole country, and it's about time.
That actually brings me to my final question, which is for you, Baroness Butler-Sloss, and it's still on child trafficking.
I'm Elizabeth.
What's that?
I said I'm Elizabeth.
But what is it? I think.
Said Baroness. It's all right.
I'm sorry.
I'm sorry.
I don't dig Baroness unless I have
got
to.
the wrong name. Apologies.
I just called myself Elizabeth. That was all.
But I just wanted to ask about the government's new proposal for a specific offence of child criminal exploitation, and what your view on that was.
I was listening to Caroline with great interest because, of course, she has hugely more experience than me. Yes, I was a judge, family judge. I never tried crime if I could avoid it. And I had thought in my innocence that probably the child exploitation new crime might be helpful. But I can see from her point of view it might actually be difficult, and I understand the point she makes that if you're exploited, it doesn't matter if you're a child or an adult. So when it comes through the House of Lords, I think I will now ask some questions. So I'm not sure is the answer. I wasn't against it, but I'm wondering how in fact it will work. I'm not sure. Trouble is the ministers aren't lawyers.
If I may add to that, I think having clarity for safeguarding professionals about what to look out for when identifying victims is helpful. And particularly when we see child victims, the majority of children referred are UK nationals and the majority are boys that identify for child criminal exploitation. I think it's therefore helpful to provide that clarity on actually what individuals should be looking for when seeing a child in front of them who may be victim to this. I would like to see there as well child sexual exploitation being defined too. Whilst I welcome the government looking at child criminal exploitation, I think it overlooks the fact that we've actually seen a big rise in the number of girls being referred for child sexual exploitation into the National Referral Mechanism, and also, worryingly, an increase in girls who are under the age of 15 being referred. This is an area actually where professionals aren't that good at identifying sexual exploitation. there's not clarity between different government departments on what they would even define child sexual exploitation to be. The Department for Education has a different definition to the Home Office, and victims themselves would consider there to be a different definition to the one that the government uses. So great that we're looking at child criminal exploitation, but I actually also think the government needs to define wider terms.
I'm just wondering whether, in fact, it would be better to amend the Modern Slavery Act to identify especially children or something like that, but not therefore to lose the point that Caroline's making, that it's everybody. But I do think the reason why I was in favour of it is exactly the reason that the Commissioner said, that I think people don't understand. And if you had a child exploitation, either labour or, I would put labour or sexual, something like that, and have it as an addition to or an amendment to the Modern Slavery Act. If we were, I'll go away and look at it.
I'm very grateful you said that, because these were amendments I was thinking of as well. Chris, have you finished? Yeah. So that just brings me to the final question, which is the same question I put to the first panel, which is what legislative and non-legislative changes could we be pushing for as a committee that you would like to see that would A, make your life easier, and B, make the whole system work better?
I'm very concerned about the post legislation. I'm concerned about data. I don't think data is being kept across the country. I'm thinking of England and Wales, by everyone who has anything to do with it. So I'm talking about the first responders, I'm talking about the police, talking about the CPS, the Crown Prosecution Service, talking about the Home Office, talking about NGOs. I think we ought really to be treating data seriously. I might look at Portugal. Years ago I went to Portugal, where they actually kept data on every single person who was identified as a potential victim of modern slavery. And they kept it all in Lisbon. But of course it's a small country. But I think we could do a great deal better. Care workers, our House of Lords committee looked at the fact that care workers that we didn't think about in 2015 have become a real considerable concern, particularly with overseas exploitation, and paying huge amounts of money to be able to be referred for a visa. Yes. Secondly, the visa is inadequate because if they are being exploited, it's very difficult for them to get another job. And what's being held over them is the fact by their exploiter that if they don't work for them, they'll be deported. And I mean, that is, I think, a major concern. I'm very concerned.
Like we had with overseas domestic workers in the day.
That was my next one.
Yeah.
Yes, indeed. Domestic servitude, which is, I forget which section 53, I think, of the 2015 Act. They are in exactly the same problem. I've come across examples of a woman working 7 days a week, sleeping on the floor of the kitchen, working all hours of the day and night and not being paid a penny. But she was being told by the family who brought her from the Middle East, I think she was a Filipino, that if she fled, she would just be sent back to the Philippines. And that's a powerful threat. There's a public authority's duty to notify under Section 52 of the Act. I don't think public authorities understand it. I'm not sure the public authorities have any idea they have that obligation under the Act. It's worth just looking at it. I only thought about it because someone reminded me very recently. And the last, I'm also concerned about child advocates. The supply chains, I gather you're not looking at because the Joint Committee, I gather, on Human Rights is looking at supply chains. Prosecutions and defences, Caroline and the others have dealt with. The last one are the orders, reparation orders, which are not very often applied. Prevention and risk orders, which are excellent, but they're only dealt with in the Magistrates' Court. They refer to the Crown Court in the Act, but as far as I understand it, you can't have to get an order from the Magistrates' Court. I can't understand why the Crown Court can't do it. And that's we've asked for in 2019. And it's a very small point, but it does seem to me that it would be very sensible for the Crown Court, who's adjourning a case for trial probably in a year's time, could actually make a risk or prevention order to help the victims. And my last one is a freezing orders. This is a civil thing, but if you find someone who is, as Caroline was saying, this is an issue of greed. They become rich. If you know what their bank accounts are, there's no reason why the police or the CPS couldn't go to the civil court and apply for a freezing order. But you need to apply for it very early, because it's very easy, as everybody knows, to get the money out of the country.
Thank you.
In terms of legislative change, I think it'd be remiss for me not to say, obviously today the Great British Energy Bill will be debated in the Commons. Lord Alton's amendment on making sure that the Great British Energy body does not procure goods which are made by slave labour is something that I think all MPs should be voting on and accepting. And Alex Sobel MP has also tabled an amendment which I welcome. We're here reflecting back on the last 10 years and what's changed to tackle modern slavery. I think it's really important that the government looks at its own supply chains and its own procurement, and actually that has checks and balances in place, and those same checks that they ask businesses to take on too. So I think that is a legislative change that I would like to see today in terms of happening in the Commons. Beyond today, though, I think it's really important that mandatory human rights due diligence is implemented in terms of new legislation. Our international partners have done that and we are falling behind them. And in terms of non-legislative change, I think it's back to some of the themes that we've touched on today in terms of there should be a cross-government strategy which outlines clear political will and leadership in this space. This strategy matters not only for what government departments should do and what officials should do, but law enforcement need it too, so they can put it in their control strategies. Local authorities want this strategy too, so that they can see what they should be doing and how they contribute to the bigger picture. And of course, funding often streams from strategies and outlines of how work will be delivered. So that would be my main non-legislative change, alongside a Survivor Advisory Council.
Thank you. And the US hot goods provisions, would you welcome seeing something like those here?
Yeah.
So would I, very much so. You may remember, Madam Chair, that we actually listened to the American Border Police explaining to us how they stopped hot goods from even entering the United States. Brilliant. We ought to look at it.
We really should. Unless anyone's got anything else, or unless there's anything else you want to say, can I thank you very much for coming and being part of this historic, I think, evidence session. 10 years of a landmark piece of legislation should be commemorated. We will have our debate on Thursday in the House of Commons chamber, and your evidence will absolutely help to make sure that debate is even more vivid and lively than it perhaps would have otherwise have been. But also thank you for all the work you've done over the years and will continue to do. With that, I conclude the session. Order.